Good morning, thank you. Please be seated. We are here in our cause number CR12342 involving the state of Arizona versus Ryan Frank Crandall. This is the time set for oral argument. Each side will have 20 minutes. The appellant, if you'd like to save some time for rebuttal, we will let you manage the clock which is on the podium. We will be recording this, both audio and video. Go to YouTube in the near future and you can watch this and you can put it to music later on. We have read the briefs to include the supplemental that has been provided. We've conferenced this matter. We seem to understand the issues. And with that, Counsel.
Good morning. May it please the court and counsel. My name is Corey Engel. I am the attorney on behalf of appellant, Mr. Crandall. And, quote, "There was nothing to indicate that the victim was being aggressive toward the defendant at that barbecue. There was nothing to indicate he was being aggressive toward the defendant or anyone at the bar," end quote. Those were the prosecutor's words during his argument to the jury in his closing. He also argued that there is nothing other than the defendant's version of events that indicates he acted reasonably. The prosecutor further referenced at least twice that no independent witnesses supported the defendant, but that the victim did have an independent witness. And for his part, the victim testified he was not angry at all at the bar, he was not staring aggressively, and he was not attempting to pick a fight while he was at the bar. Those are the operative, most important facts in this case, which presents the question of whether appellant should have been allowed to present specific other act evidence of the victim, of which he was aware, in support of his self-defense claim.
Through Mr. Anaya.
That's correct, Your Honor.
What does the record say Mr. Anaya would have said, as specifically as you can, please?
Okay, as specifically as I can, Anaya would have said, and this is from the offer of proof, which was actually made by the state during the argument in front of the court, in an odd twist.
A little odd, yeah.
Yes. 1 to 2 hours before the incident at the house, where the actual fight, they were at a bar. Anaya was talking to a woman. The victim came up, got in between the two of them, was staring aggressively at the Anaya. He crossed his arms. He bared his teeth and growled at Anaya until Anaya was so uncomfortable that he left and went to another portion of the bar. So that was the testimony about the confrontation that happened between the victim and Anaya at the bar, and what Anaya would have testified to.
Is this to be interpreted in your view as violent, aggressive behavior, or as some, I don't know, bad behavior, or to me, strange attempt to pick up this woman?
Your Honor, it may not qualify as violent behavior, but in context, considered in context with all of the other behavior by the victim that night, it presents a piece of an ongoing pattern of aggression and an attempt to start a fight. And that's what the defendant was testifying to, that what he witnessed from the victim at all different points during the night was a continuing, unrelenting aggression towards other people and an attempt to pick a fight.
How much time would have been from the time of the? I hate to admit that this case is where I learned the term mad dogging, as it was in the briefs or in the record. I don't recall, but how much time from the alleged mad dogging until the actual injury and fight?
During the offer of proof, the state indicated it was between 1 to 2 hours. The defense counsel interjected that it was closer to 1 hour prior. So that would have been while they were at the bar, just prior to driving home in the truck and the DUI and the incidents that occurred in the truck. And then that was shortly before the actual fight at the house.
So we have the driving in the pickup, the being stopped by the officer, the carrying on that was associated with that, then some walking and others driving back to the house and then the confrontation.
Yes. And the incidents of aggression by the victim during those times include the victim confronting Anaya at the bar, the victim verbally confronting the defendant in the back of the truck because the defendant knew the police officer, then the victim confronting the third man in the back of the truck and the defendant because of their actions he believed caused the police officer to stop them for the DUI. So that was another argument that he got into with both men in the back of the truck. The victim was warned not to go back to the house. He did so anyhow when the defendant arrived. He actually arrived after the victim got back to the house. The victim was...
Jurors are aware of these other incidents.
Yes, the defendant testified to each one of the other pieces.
Well, would it have been significant if, say, Mr. Anaya had seen something 3 days earlier, or there was someone who just said, I saw the victim yell at his own brother 2 weeks ago?
I think that would be a different case. The defense in this case was specifically that the defendant believed he was acting reasonably when he hit the victim initially, because the victim had been so aggressive with so many people over the course of the night and unrelenting in that aggression. It appeared that he was trying to pick a physical argument with someone. And so when the defendant was grabbed by the victim, it feeds into his state of mind, the defendant's state of mind. And
Wouldn't it also feed into his state of mind if it had just, he heard that the victim had argued with his own brother the day before, and he just seems to be a hothead? Is that something that we would necessarily have to consider?
Yes, but not to the same degree as this current incident, which was so close in time and nearly part of the same transaction. It's a course of continuing conduct by the victim that if something happened the day before that none of these people were actually a party to, and the defendant didn't actually witness the verbal confrontation between the victim and his brother in your example, that wouldn't be able to play then into...
But I'm assuming that he did witness, say he just argued with someone. It doesn't seem, I'm having a hard time seeing how significant this, when it doesn't seem like a violent act, and the defendant obviously continues to spend time with the guy. It didn't seem to have been something that rose to that level where it upset him enough to not spend time with him.
Well, the defendant did testify that he got out of the truck in part because he was afraid the victim was going to hit him, and he wanted to remove himself from that situation. He did tell the victim before he left that the victim was not welcome to come back to his house. So I believe that the defendant was showing that he did understand that there was some sort of an ongoing threat from this victim. Whether or not that would apply to, a verbal situation that happened the day before with the victim's brother, I don't think that that's as probative as something that happened shortly beforehand that shows that the victim is trying to start a physical fight with someone.
Does it change the analysis for you at all that there were a number of witnesses to the actual incident? It just strikes me this is different than, say, the Fish case where we really don't know what happened, and maybe you somehow want to try to figure out what happened, but where you have a number of witnesses where there doesn't seem to be much conflicting testimony as to what happened. Does that affect the analysis? I
think it does affect the analysis. This isn't a Fish case and wouldn't fit necessarily within the exception set in Fish, specifically where you have no eyewitnesses and you need the testimony. The reason you need this testimony is not to know exactly what happened. It's to know why it is the defendant thought he had to act in a specific way. And the fact that the state argued that the defendant didn't have any corroborating witnesses, and that was important and that the jury should consider that makes the fact that Anaya would have testified in concert with what the defendant testified to and in opposition to what the victim said. The victim said, I wasn't angry at anybody at the bar. There was no aggressiveness. I didn't, stare at anyone. I wasn't trying to pick a fight. The victim testified to that. The defendant testified opposite that. The state argued there were no corroborating witnesses to what the defendant had to say, but there was, and the state knew it and had managed to get it precluded. And so in this case, that testimony from Anaya would have actually been important to that, regardless of what the victim or the other witnesses actually saw at the scene. That corroboration for what the defendant believed and impeaching the victim on what happened earlier was still important.
Was the Anaya testimony promoted by the defense as impeachment witness, impeachment testimony regarding what the victim had testified to?
No, I don't believe it was. I don't believe at that time, because the defense was not allowed to have an interview with the victim, the only statements they would have from the victim would be whatever the victim said to the police officer. So until the testimony was proposed and came out at trial, the defense wouldn't necessarily know that the victim was going to deny that anything had happened at the bar.
I was thinking, I may be confused, I was thinking that the victim had testified before the Anaya testimony was proposed and rejected.
No, the
Okay.
argument happened prior to all of the testimony.
But at least it then wasn't renewed after the victim testified, and the defense then heard that he said whatever he was going to say.
That's correct. The defense attorney did not renew specifically based on the new basis, right, of impeachment.
And so you have Anaya, but you would also need, as I understood the record, the defense investigator. You showed Mr. Anaya a lineup, and he would say, or at least I think the offer was, he was about 60 to 70% sure that it was
Right.
the victim who did that. So you would have that lineup, that witness, as well as Mr. Anaya testifying.
That would be correct, Your Honor, unless when the witness, Anaya, came into court, he felt he was able to actually make an identification in court. If he were able to do that, then that would obviate the need to have the investigator testify about the lineup. If the court wanted to try and limit the extra information that was coming in solely because Anaya was testifying. And we don't know for sure whether or not Anaya would have been able to say when he was sitting in court, yes, I see the victim, and that is the person who confronted me at the bar.
But wouldn't that be relevant to go through and explain, wouldn't the state want to point out, but you weren't certain the first time it was 60 to 70%?
Yes, I think it would be relevant, and if the state wanted to impeach the witness with that, they should be able to do so. I don't think that would have added substantially to, the issues in front of the jury or confused the jury overly much in trials where photo lineups are gotten into. So long as there isn't an objection to the way the lineup is actually made, that testimony usually can take place over the course of, just a few pages of transcripts. So
Yeah, but generally it's the state presenting the lineup.
that is true.
And
That is true.
Most times it's at a Deseret hearing that, goes in the detail, and then at the trial it's fairly perfunctory, given the court's earlier ruling.
During the oral argument on Mr. Anaya's testimony, the state's objections didn't relate to anything to do with the lineup or not wanting to have the investigator called as a witness. It just related to the 404B and whether an exception existed. So it was basically objection on the substance of the actual testimony, whether it should be allowed in.
And what was the trial court's reason for not allowing it?
That is a good question, Your Honor.
As best you can tell.
It seems that the court originally said, the defendant argued first that the testimony should come in because the defendant was aware of the prior incident and that it went to his state of mind and the reasonableness of his actions. The court denied when the admissibility at that point. Then all of the parties pivoted to talk about fish and whether or not this fit within a fish exception. The court then issued another denial, not really getting into whether the evidence met the standard, whether the court didn't believe the evidence, what the reasoning was.
Did the state argue at trial that this kind of evidence would be admissible under 404B only in homicide cases?
No, it did not. That is a new argument, Your Honor. The last question for this court, I think we've covered most of the things I was going to talk to you about, but the last question is whether or not, if this is an error, whether or not it's a harmless error. The standard is whether or not this court could conclude beyond a reasonable doubt that the error did not contribute or affect the verdict. And because the defendant testified to the prior incident, it may seem on its surface that this is not an important piece of evidence to have come in. But I think I've explained to the court, when you consider what the victim had to say outside of this incident, what you have is the victim saying, well, I was angry about the DUI. I got verbally aggressive with the people in the truck about that. And I got verbally aggressive back at the house about the DUI, and that was it. What you have, if you add in Mr. Anaya's testimony, is a completely different set of circumstances. It dovetails with what the defendant was saying, which was that from his perspective, the victim was attempting all night long to start a fight. He confronted someone at the bar that had nothing to do with the DUI, that the victim didn't even know. He confronted a person in the truck about the DUI, and the person who was getting the DUI was not someone the victim had ever met before or knew before. The victim confronted the defendant in the truck. Even when he was warned not to go back to the house, the victim did so. The victim, when the defendant arrived at the house, was yelling at an entirely different group of people and was aggressive with them, and then was again aggressive when the defendant walked up. So what you have, if you don't have Mr. Anaya's testimony, is the victim's actions seemingly a little aggressive verbally, but fairly reasonable given what was happening and that everybody was drinking. What you have if Mr. Anaya's testimony comes in is the victim impeached on what happened at the bar, but also impeached on the idea that he wasn't being aggressive all night long. He was, and with different people, which led the defendant to believe that when the victim grabbed his arm, that the victim intended to escalate this altercation.
Well, but that's, okay. So you're saying in order to get to the fact that the jury would have to believe that the arm was grabbed in spite of the other testimony, to the contrary, that he was walking by, he grabbed his arm, and then he swung and hit him, would be his version of the events as opposed to what other witnesses had testified to.
Correct. And Your Honor, if I may, I would like to reserve the remaining 4 minutes for my rebuttal. Thank you.
Okay. Thank you.
Good morning. Excuse me. Good morning, Your Honors. May it please the Court. My name is Jana Zinman. I am an Assistant Attorney General, and I represent this appellee, the state, in this matter. Appellant argues that the evidence is admissible to show that Christopher, the victim, was the initial aggressor and to show appellant's state of mind. However, this evidence would not have been admissible under either, first and foremost because it wasn't relevant. It was directed at a third party, not at appellant. It was a different time. It was a different location.
Well, wouldn't it have some relevance to, as we've just heard, the defendant's state of mind, and go, you know, I got to watch this guy. You know, he's trying to pick a fight in a bar with a guy I don't know. You know, and then all of a sudden you've got the dancing in the truck and the DUI stop. Doesn't it fit into that mold of another piece of evidence, at least that the defense could provide to attempt to show that there truly was a justification defense?
No, because in order to have that evidence admitted, it would have to be an act of violence. And here, there is absolutely no act of violence. As Judge Gemmel pointed out, it could even be like a strange attempt to hit on a woman. It could be construed as silly, obnoxious behavior, boorish even. There's absolutely no violence whatsoever. So a reasonable person, when they're thinking about why would the appellant need to react with such strong, brutal physical force in response to having his shirt tugged on, there's absolutely no connection to a prior event of growling at a third party at a bar.
So it seems different than the fact that it's a third party. If he'd done more than growling, if, say, he'd actually physically hit the third person, would you agree that it would be relevant?
Absolutely. If there was physical contact to show that this was an act of violence, definitely. If, for example, in the bar, the victim had walked up to the third party and tugged on his shirt, and when the third party turned around, he took out a knife and said, "I'm going to kill you," and attempted to kill him, then later on when he tugged on the shirt of the appellant, that would be reasonable to justify the amount of brutal force that he used. But in this case, there is no physical interaction at all. All we have is a verbal altercation, and verbal altercation is not allowed. There's no defense under the self-defense statute of 13-404B for just a verbal provocation.
But
You can't
if it doesn't have
respond.
anything to do with the fact that it's a third person and it's really not that bad, why isn't that something that the state could just argue and make the explanation, this really isn't that bad?
It should have been allowed in, well, as I was saying, because of the relevance. And then also, if you look at the other rules of evidence, we have 403. It's so minimally probative that it'd be outweighed by it could mislead the jury. The jury might say, wow, they're really putting this emphasis on the growling. Maybe there is some type of, connection here that I'm missing. Maybe I really need to focus on that. Moreover, it wouldn't have been allowed under 405A or B. It's not reputation or opinion evidence, and it's not an essential element of the defense. And as the case law clearly states, even acts of aggression aren't considered an element of the defense, nor is the identity of the original aggressor. So it wouldn't be allowed under these rules of evidence, and the trial court didn't abuse its discretion in precluding it. So looking at the initial aggressor, as I was just saying, it would have been precluded under 405A and B. And then going to state of mind, the court did correctly preclude it. The prior act didn't explain why a reasonable person in appellant's position would use the force against the victim just simply from the tugging on the shirt.
Well, did the court just rely on Fish and 404B, or did the court do a 401, 403, 405 analysis?
Well,
Or do we, I've tried to read the transcript to understand that, and I don't necessarily know that I've come to any clear conclusion.
I mean, there is the presumption that the court does consider all the rules of evidence under Warner. And so while the court may have just voiced on the record 404B as well as Fish, we presume that the court does consider all the rules that are necessary.
We presume that the court knows the law and follow it?
Correct.
Okay.
Correct.
Are you suggesting there would be a different result if this were a homicide case?
A different result as far as whether that evidence would have been allowed in?
Right.
No, actually. I don't think it would have been a different result because it's still not an act of violence. And so a reasonable person wouldn't have believed that just verbal
So the argument that
provocation
you've
alone.
made that relating to the case law that discusses whether it's admissible in a homicide case, why is it different than when it's an aggravated assault case compared to, or just an assault case compared to a homicide case?
Well, all the cases like Williams and Connor and the different cases really are focused on the homicide because you're trying to show that that deadly force was necessary. And here, if you're considering expanding it to an aggravated assault, the facts of this case are not the ones to do it in because there was no violence whatsoever. It was just simply putting it in the best light for appellate, potentially an act of aggression. That's all that we have here. There was no violence at all. So,
Isn't that just the argument that the state makes? I'm just having a hard time seeing the distinction between a rule for a homicide case and a rule for an assault case. Isn't it just an assault that gets a little bit worse and somebody dies?
but you still have to show that a reasonable amount of force was necessary. And when you look at the basic facts here, we have the victim tugging on appellant's shirt, and appellant turning around and responding with punching him and dislocating his shoulder and breaking his foot and breaking his nose, and this brutal force where you could actually argue that there was, maybe even attempted murder. I mean, he had his hand over the victim's face. He's saying, "Good night, you're done." And the victim felt like, I might die here. I've got to bite his finger in order to survive. And that amount of brutal force isn't justified really from growling at a random person at a bar, a couple hours earlier. And so the facts here don't suggest that any type of physical force was necessary, and it wouldn't be. That's how it greatly differs from a homicide case where you have to show that force is necessary. There was no force that should have been used here.
Am I following you correctly that you're not so much arguing that this general kind of evidence that might go to the state of mind of the defendant is inadmissible because it might be admissible under 404B, but rather you're arguing that this evidence simply isn't violent enough and indicative enough and related enough to be admissible.
Well, it's not admissible under 404B because it would be trying to get propensity evidence to show that the victim had a propensity for violence, and there was no exception that was argued. So it definitely wouldn't be admissible under 404B. What could have been admissible that wasn't offered in this case was if you had the witness say, I saw the guy in a bar, and my opinion is he's aggressive. He wouldn't have been allowed to do that specific act, but that was never offered here. He never wanted to say, under 405A,
That would be.
this
that
is
might
my
be
reputation or opinion.
That might be admissible if the defendant knew of that ahead of time,
Right, but
by seeing it or by being told it.
right. So, but there was no reputation or opinion evidence that was offered here. All we have is a specific act, and so that would be precluded under 405B.
Isn't it different when the defendant is aware of the specific act? Doesn't that change the analysis? We're not just asking for someone to come in and just offer some random act. This is something that the defendant saw, and so it presumably affects his state of mind or the way he reacts to the victim.
Absolutely, and the defendant was actually able to testify about what he observed in that bar. So he said, and the words that he used were actually stronger than what the witness would have testified to, because he said.
But why isn't he entitled to have somebody corroborate what he said?
Well, Fish actually discusses corroboration, and if you look at that, we have, they allowed the corroboration, first of all, because there was no eyewitness in Fish, for example, to corroborate what he's saying. And here we do. We have this sober witness, the only sober person there, that said, yeah, I saw this happen. And she was pretty neutral, actually, if not more towards the appellant, because she actually had met the appellant on several occasions and only met the victim on one other occasion. They also, in order to have the corroboration allowed, you also have to have it pass, 404, 403, and it wouldn't have passed in these tests. So it wouldn't have been allowed under the corroboration. Finally, I would like
I was
to.
going to say, maybe one of the issues, or at least it appears, that there's a dichotomy between homicide and garden variety assault is generally when our Supreme Court talks, it's only in a death penalty case, so, or in a rare decision. They generally don't take a lot of, at least write opinions in a lot of ag assault cases, but maybe this is a one that they will.
Well, nonetheless, you would still have to show that the violence occurred, and we don't have that in that situation. And if you did find that the evidence was improperly precluded, it would absolutely be harmless error, because there's no reasonable probability that the verdict would have been different had this evidence been permitted. We have it wasn't directed at the defendant, the lapse of time, different place. It was allowed in through the defendant's testimony. And if anything, this behavior, the verbal disagreements that went on, showed that the victim acted with restraint. I mean, we have these separate incidences throughout the night where, yeah, he yelled in the back of the truck, and he yelled the guys, at the barbecue, but he never once attempted to make any physical contact. And that's true with this barbecue. So anything, it's not showing that, I have a reason to fear for my safety. We have this victim, and he's showing restraint. When he gets mad, he yells, or maybe he even growls, but he doesn't act with violence.
On the subject of harmless error, I think part of Ms. Engel's argument, as I understand it, is that here's another witness who doesn't know Crandall, who's presumably an independent witness, and if he could have been allowed to testify, he may have not added that much new information that wasn't already before the jury, but he would have corroborated what Mr. Crandall was saying and not what the victim was saying, and that may have tilted the jury's evaluation of the credibility between the victim and Crandall, which is really what decides the case.
Well, here we have the witness actually was a friend of Crandall's. He was not an independent witness. And also
You're talking the witness?
Anaya.
Mr.
Naya was
Mr.
a friend
Anaya,
of
yes.
Crandall's. Okay,
He was-
I didn't get that.
I believe that he was a friend of the appellant's.
I didn't get that.
An appellant here was allowed to present a complete defense. He wasn't denied that opportunity.
But he was allowed to testify about it, but that's not the same as having somebody else come in and testify about it as well.
But it would nonetheless have to have been admissible under the rules of evidence, and it wouldn't have passed the 403, it wouldn't have passed 401, it was irrelevant under 402, it wouldn't have been admitted under 405A or B, or under 404B, so it was properly precluded. And we also have him saying to Officer Hastings, you know, he disrespected me. I mean, he's not showing this legal defense of self-defense. He's saying, I was disrespected. I was mad. This is why I responded the way I did. I didn't respond because I was concerned about being growled at. I responded with the physical force because I felt disrespected. So the appellant's use of violence was unreasonable, and there's no conceivable way that the jury's verdict would have changed had Anaya's testimony been admitted. We ask, if there's no further questions, we ask that you affirm appellant's conviction and sentence on appeal. Thank you.
Thank you.
Your Honor, the state is using the wrong standard with regard to harmless error. The state is asking whether or not the verdict would be different if this evidence came in. But the standard is whether or not the verdict as it was actually rendered can be said beyond a reasonable doubt not to have been affected by the error in precluding the evidence. And those are two different standards. The question with regard to whether or not this was an act of violence versus an act of aggression, those are really questions that go to the weight of the evidence, how much weight the jury should give to the particular piece of evidence as it comes in, and whether or not that piece of evidence proves or disproves the self-defense claim. The question here is not whether or not the defendant would succeed on his self-defense claim, or whether or not we all would have voted guilty or not guilty if we were on the jury. The question is whether or not the defendant should be allowed at all to talk about this piece of evidence to the jury, to even be able to argue the piece of evidence to the jury. And that standard is just relevancy. Whether or not is it relevant to some fact and issue. And when the fact and issue is what the defendant believed when the victim grabbed him, the fact of the prior aggression at the bar, whether it was actually violent or whether it was merely running up and getting in someone's face and making them believe you could become violent, which was the point the defendant was making, and which was the point he also made when he said he believes that the victim was getting ready to hit him in the back of the truck, which makes that incident consistent with the incident at the bar and consistent with the incident at the house, which is the victim or the defendant believed that when the victim grabbed his arm, that it wasn't just to continue to keep talking to him, that it was to escalate into the actual physical violence that the defendant believed was imminent the whole night long.
Let me ask you to speak a little more, if you will, on the subject of what I'll call, well, it's really relevant. It's the same thing you've just been addressing, I think, but I'm focusing on the fact that this growling or mad dogging, whatever that is, seems a little seems susceptible to different interpretations. It was an hour or two. There were a bunch of things that intervened. It's kind of remote, at least arguably, and since the trial judge gets to exercise discretion on the admission or exclusion of evidence, and we're reviewing only for an abuse of that discretion, wasn't it within the trial judge's discretion, even if I might have let it in, didn't the trial judge have discretion to exclude it as was done?
Your Honor, when the facts of the prior incident are not in dispute, everybody agreed what Mr. Anaya would have testified to. On appeal, the court can consider that then de novo, applying the legal standard to the facts as set forth in front of the court. There isn't a dispute about what Mr. Anaya would have testified to. There's only a dispute about whether the legal standard as applied to those facts has been met. And so I believe that the court on appeal is allowed to review that part de novo because you're applying the legal standard to the facts, not making a determination of the facts yourself.
Okay. I'm not sure I agree with that, but I'll think about it.
Okay. I believe that the court here erred specifically because it was not giving enough weight to the Connor line of cases, which says that there's a specific exception to the prior incidents not being admissible. Prior incidents that the defendant is aware of is admissible. And that's the Connor line of cases. And the court, that is why the court actually made a mistake when it precluded this evidence.
Was there a discussion about Connor and before the trial court, or what was the discussion at that point?
The defendant never mentioned the word Connor or that line of cases, but the defendant argued the specific argument at issue in that case, which was that the defendant was aware of the prior incidents and that the prior incident went to his state of mind, which was the holding in Connor. If the defendant is aware of the specific incident, then it is admissible. Excuse me.
That's part of fish also.
I was going to say, I thought at least the pleadings leading up to that we're talking was all fish.
Yes, Your Honor. I believe you're correct. And my time is up. Thank you.
Thank you very much. We appreciate the argument of counsel in this matter. It has been helpful. We will take this matter under advisement, issue our written ruling in due course. Until then, we stand adjourned. Thank you.
We just have